So try to get all your initial filings down to one sentence. You could always.
I just did a one-page claim and a one-page prologue, and I used.
Well, you get rid of the prologue, and you get your claim down to one sentence.
And the claim is that claimant holds quiet title established by verified court, public, and published record to the private lands and homes in controversy.
You don't have to put that stuff in. You just have to say, is they're interfering with my rights, or they're interfering with my property, or they're interfering with my access to property, or they're trespassing upon my property. Something very simple. And that's it. Let them ask you, would you like to embellish on that? Would you like to provide us a little more information? Because honestly, we really don't know who the hell you are. So like I said, initially, it's just like, if you ever seen like a warrant in debt, if you ever went to court, somebody owed you $500. The court clerk would say to you, what do you need? This guy owes me $499, $500, whatever they owe me. Fine. It's like, would you like to fill out a warrant of debt? It's like, what's that? And the court clerk will say, well, you put the dollar amount here, fill out the summons. They're either going to pay you in 21 days, or we're going to have them come before the judge or the jury, and they're going to explain why they should or should not pay you the $500. And that's it. So all you do on a warrant of debt is it looks like the size of a postcard. It says, put down the dollar amount you owe, put the person's name and address, say he owes me $500. That's it. You know, if you want to say he owes me $500 or past rent, okay, you can say $500 or past rent. But you're just going to piss the court clerk off because she's going to be like, oh, well, we really don't get involved between landlords and tenants. We don't really do that. We don't like to do that. I'm sure there's a contract somewhere in there, and I'm sure there's a way that you could, charge the guy a fine or a penalty or a late fee. We don't really like doing that. Like I said, my sister got summons one time to court. The guy said, you owe me $1,500. $1,500 for what? So my sister, I said to her, right, ask the man for a bill of particulars. So she had to fill out a bill of particulars. It says, itemize the $1,500. But most people don't. They just say, you owe me $1,500? Okay. And they don't bother answering, and then you get a default judgment on. So make it just simple. You owe me $1,500. If they don't know who you are, believe me, I'm sure they know who you are. If they don't know who you are, well, thank God. The clerk of the court doesn't care. It's like, oh, my God, this was the greatest paperwork I've ever filed. One sentence done. I don't want to get involved. She don't want to get involved. Believe me. She wants to go get a cup of coffee and go smoke a cigarette. She doesn't want to get involved. Like, ma'am, can you make your claim easy here? What's that? They trespassed upon my property without right and demand compensation now of $5,000. Oh, wonderful, lovely. Thank you. Boom, boom, boom. She's going to summons them to answer. They got 21 days to do it, appear in court on day 22. It's that simple.
When you ask them to issue the summons, do they give it back to you to serve it, or do they serve it themselves? Is that what you're asking them to do?
No, well, you hand them, like, that's what part of the filing fee is they, when you write out the summons there before them, like, who would you like us to drag into the bill?
I gave them 3 for the 3 wrongdoers, and when they did the case wrongly, they didn't give those back, so I reissued them when I made the correction. So do they issue the summons? I was under the impression that we have to actually serve the summons to the people.
No, you go to the court clerk. That's part of the filing fee process. That's why if you want to have them serve a summons upon 1,000 defendants, thank God you only pay the $50 filing fee because, a subpoena is different than a summons. So when you summon people to appear, the court clerk, what she will do is she will put it in like the box that goes to the sheriff's department. The sheriff's department will come there first thing in the morning, 6, 7 o'clock in the morning. He'll pick up all the summonses, and he'll give them out to the deputies and say, okay, you know where this person lives, you know where this person, this part of the state or this county, you go take care of this. And then the sheriffs and the deputies run around and they just deliver the summonses.
Do they deliver the summons and a copy of the case, or just the summons itself?
Well, I kind of figured everybody knows. All you do is you make an envelope with a copy of the claim to the wrongdoing. You stick it in a manila envelope, like a nice 8x11 envelope, whatever they call those, and you staple the summons onto the manila envelope. So when the sheriff gets it, all he's doing is holding a manila envelope in his hand. That's got a summons staple.
Now,
Right.
what if some of these people are not local? Like one of them is back in Washington D.C. in Fannie Mae's office, and one is 400 miles away.
Well, it depends. If they have offices, like if you're suing like somebody who, like an insurance company, like you're suing somebody who hit you with a car in their insurance, like State Farm or Allstate, you could sue them in your local court because they have agents all over the state, so they will answer the claim anywhere. So it's the same thing, I guess you could say, with Fannie Mae and Freddie Mac. They will answer the claim wherever they conduct business. So if they conduct business in your county, well, then they have to understand they're going to have to be obligated to settle matters in your county.
Well, I'm naming the individual who is the president CEO of Fannie Mae back in Washington, D.C.
He'll answer you. He'll give you an answer. He'll say, you know what, that's I can't come, or whatever, it's too far, or she's going to have to serve me in my local jurisdiction. I'll be glad to answer, but I can't, I believe that, she's outside of the jurisdiction in which she has any control. That court has any control. That court can't drag him back in. If he, like I said, if he says, well, you have to, if I did you wrong, you have to sue, like me, I have to sue Alabama in Alabama. I can't sue Alabama in Virginia. Even though it's convenient for me, I can. But if they had an insurance company that was indemnifying them, and I was going after them and their insurance company, then I could sue it, make a lawsuit down here in Virginia, because they have an insurance company, and insurance companies have to answer anywhere in which they provide coverage. So if they were covered by the Travelers Insurance Group out of Hartford, I was like, Travelers has everywhere in this country. Great, that's lovely. I'm just going to sue Travelers and let them, worry about how the defendants are going to get down here or whatever. But like I said, I don't know why. Like you said, you're going after Fannie Mae and Freddie Mac and personal people. I don't know. That's an awfully big. That sounds like an awfully complicated lawsuit. Where you're trying to go after those.
Well, they're trying to take our land and our home, and on a false foreclosure sale, and so that's why I'm doing the suit. And it was all done wrong, and they're still trying. I've shown them it's done wrong. I have the quiet title through different courts, and they're still trying to get it. So,
somebody who's claiming the property is theirs?
Fannie Mae.
Okay, so all you have to do is send this Fannie Mae to answer, how they believe.
I did, and I did the fair warning notice, and they've received that. And
so what did they do?
Gave him the affidavit of publication of quiet title, and another court where there was quiet title, a rescission of the deed of trust, so that the sale was based on a false premise. So there's things done. So
what did they say?
What did they say? They're just basing this on a trustee's deed that was obtained fraudulently, and that's the only thing they're looking at. Even though there's other things in the public record. I'm saying
you really got to go back and listen to how I do things, because what you're doing is way too complicated. And this stuff is so simple, it's scary. All you have to say is who's making a claim for this property. Don't get cute. Just say who's making a claim for this property. Who's ever making a claim for this property. Let them speak now, forever hold their peace. Come to court under oath of affirmation and verify your claim to be true. Or any claim or interest that you have in this property will be deemed void from here on for the rest of eternity. Just make it simple. None of this, ma'am, I'm telling you, I'm not, who does this show? John Stewart. John Stewart does like an Angela call on Sunday, and he will talk to you for hours about how to do quiet title, and I go around with him and stuff, and I make it beyond simple, and he doesn't like it simple. He likes it complicated, and he likes to act like an attorney, and he likes to do quiet title and cesticate deed trust. He likes to do all this silly nonsense. And I'm saying there is no man from Fannie Mae or Freddie Mac who will ever appear in any court to testify in the oath of affirmation that Freddie Mae or Freddie Mac has any claim to that property that you claim is yours. They will never do it. So make that one sentence to Freddie Mae and say, I believe that no man, Freddie Mae, Freddie Mac will ever come to court under oath of affirmation verify that any claim to that property is true. So I order you to cease and desist any action in which is interfering with my right to that property. It's simple. Now, if you want to talk like a lawyer and you want to do these 500 books that, like I said, like Mr. Stewart, nice man. We talk nice and pleasant to each other. But it's insane. I am not spending my life studying how to be a lawyer and acting like a lawyer and talking like a lawyer and submitting paperwork like a lawyer. I'm not a lawyer. I'm a man. This is my property. Does anybody have a claim to this? Yes or no? Come to court under oath of affirmation. We're doing it on Tuesday. Put your hand on the Bible, swear to it, and prove to that jury that that land is yours. Do it.
I did that in fair warning notice. I said no man will make a claim saying our claim is untrue. And we gave the right to administrate it.
And you made that one sentence thing, and you were done, right? No, you got to keep putting paperwork attached. You're attaching all kinds of exhibits. You're attaching all kinds of nonsense. You just make a simple claim to them and say you got 21 days to respond. You got 21 days to answer. I'm taking you to court, and I'm going to take you before a court of record. And you're going to have to come here because a court of record is the Supreme Court of this land. And that's what I'm saying, literally, this land. It doesn't mean dirt. It means the supreme law of the people. The Supreme Court of the government is the Supreme Court of the United States. That's the Supreme Court of the government, of one of the three branches of the government. They determine controversies between the executive branch and the legislative branch. That's what the Supreme Court of the United States does. It doesn't get involved with the people. We have a court for the people. It's called a court of record. And we move by trial by jury. That's the supreme law of the land. Not the dirt, the land. The people. It's that simple. So all you do is you say to them, I'm going to move you before a court of record, a trial by jury. They know Article 7. They know that Article 7 of the Bill of Rights of the Constitution, what you call the 7th Amendment. They know it. They know exactly what it means. And once a trial by jury in a court of record, and it only moves under the common law, and only a man can testify before a common law court of record. You better bring a man forward, and he could prove, beyond a shadow of a doubt, that that's his land. Oh, I'm claiming on behalf of Freddie Mae and Freddie Mac. Well, Mr. Freddie Mae or Freddie Mac, Mr. or Mrs. Freddie, because I'm not really sure if it's male or female, they better appear, and they better make their claim. Let them make their claim. I was like, well, you know and I know they can't. Well, I don't know. Maybe there really is somebody called Freddie Mae. Maybe there really is somebody called Fannie Mac. I don't know. I'm just some stupid schmo out here in the middle of nowhere land. I don't know. All I know is somebody named Fannie keeps saying that I'm on her land. Let her come forward and make a claim, or forever hold the peace. It's that simple. Now, if you want to talk like a lawyer, John Stewart's show on Sunday, he's awesome. He will do all this nonsense with you for hours. I won't. I'll just say, look, this is very simple. If you don't want to use the court of record, if you don't want to use that this is a common law nation, if you don't understand that the supreme law, the Supreme Court of this land is a court of record, and the people and the jury makes the laws of this land and establishes whether they're true or not, okay, don't. If you believe that the legal society and all their code books and all their rules and their Supreme Courts make the rules for you to live under, well, God bless you. That's like a two-dimensional world. If you want to live in a two-dimensional paper world, you just do it. If you believe a piece of paper can control you, God bless you. To me, only a man could control me. Only another man could touch me and force me to do something if I'm causing him harm. A piece of paper can't say, well, you're causing me harm. I'm going to take you over. Oh, really? I'd like to see you do that, piece of paper. I'd really like to see you touch my body and force me into a cage. I'd like to see you do it. I explained a little earlier that old man in England said to the bailiff, touch me and I'm going to sue you. I don't care what that judge said. I don't care what his order says. I don't care what his piece of paper says. You touch me, you're the one I'm going to sue. You're the one who I'm going to own. You're the one who I'm going to sue and take his pension. Just because Adolf Hitler told everybody to throw all these women in jail and kill them, those German soldiers that did it after the war, they were killed. It's like, because you know right from wrong. You know not to kill. And you know if you kill, you're going to be killed. Well, I was ordered to do so, and I had a piece of paper, and it said, I don't care what your two-dimensional silly piece of paper said. You know it, I know. If Adolf Hitler told you to kill your mama and your children, you wouldn't have done it. But since they weren't your mama, and since that wasn't your child, well, okay, I'll kill them. If it was your mama and child, you'd figure out a way to get them out of the country. So what made you think your mama and child was any better than that man's mama or child? So it was a wonderful thing, those Nuremberg trials. It was lovely. That way you folks can understand the difference between a two-dimensional world and a three-dimensional world. You can't be controlled by a two-dimensional piece of paper. And if you choose to hold your loyalty in to a two-dimensional world, the three-dimensional world is going to come down on you someday. So I think the stuff is super simple. And you guys, if you want to play pro ses and you want to play attorneys, this is just what's going to happen. You guys are going to get run over like a freight train because you are not going to beat them at their own game. You're not going to beat them at their, well, I got a land patent. You're not going to beat them at their own verbiage. You ain't going to beat them at their own